diplomatic and consular staff in Iran case. It is a public international law case brought to the ICJ by the United States of America against Iran in response to the Iran hostage crisis, where United States diplomatic officers and personnel were seized by militant revolutionaries. On 4 September 1979, Iranian students seized the U.S. Embassy in Tehran and a number of consulates in outlying cities. The Iranian authorities failed to protect the embassy. Over 50 U.S. nationals with mostly diplomatic and consular staff were held for 444 days. Therefore, from the side of US, they request that government of Iran should immediately release all hostages of US nationals and facilitate prompt and safe departure from this person and all US officers with dignity and humane. Besides, government of Iran should clear all the premises of US embassy and restore the control of embassy. The act of the government of Iran had violated international treaties, which is the Vienna Convention on Diplomatic Relations in 1961, the Vienna Convention on Consular Relations in 1963, and the Treaty of Amity, Economic Relations and Consular Rights of 1955 between US and Iran. The first one is the violation of the missions. In Vienna Convention Diplomatic Relations 1961, in Article 27, the receiving states shall permit and protect free communication on the part of the mission for all official purposes. The second one is the violation of diplomatic agents. In Article 29, the person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take all appropriate steps to prevent any attack on his person, freedom, or dignity. So here comes the court decision. The ICJ decided that Iran must release the hostages, return the possession of US embassy and its related documents. In a conclusion, Iran did not comply with the court's judgment immediately. However, this matter solved through the negotiations between US and Iran in Algiers Accord.
Diplomatic Claim Ethiopia Claim 8. This claim is brought to the specially constituted commission by the claimant, which is the Federal Democratic Republic of Ethiopia, pursuant to Article 5 of the agreement between the government of the Federal Democratic Republic of Ethiopia and the government of the State of Eritrea of December 12, 2000. The claimant asked the Commission to find the respondent, which is the State of Eritrea, liable for loss, damage, and injuries suffered by Ethiopia from the injuries sustained by the Ethiopian diplomatic mission and consular posts and personnel in Eritrea as a result of the respondent alleged violation of the international law of diplomatic and consular relations. Ethiopia complained that Eritrea violated Article 26, 29, and 31 of the Vienna Convention on Diplomatic Relations by mistreating the Ethiopian charge in several respects. In brief, Article 26 protects free travel in the territory of the receiving state, while Article 29 states the person of a diplomatic agent shall be inviolable. The receiving state shall treat him with due respect and shall take all appropriate steps to prevent any attack on his person, freedom, or dignity. The claimant claimed that Eritrean guards twice detained and interrogated the charge at local police station after he visited Ethiopian national in Abashon in September 1998 and Medibio in October 1999. Eritrea defense is based largely on the lack of corroborating description of press account by international reported accompanying the charge on the related consular threat, which the Commission does not consider necessary to resolve Ethiopia prima facie argument. The Commission holds Eritrea responsible for breaching Article 29 of the Vienna Convention on Foreign Relations by capturing and briefly detaining the Ethiopian charge affair without respect for his diplomatic immunity in September 1998 and October 1999. The Commission does not consider that these circumstances also gave rise to violation of Article 26 or Article 31 of the Convention, nor is the Commission convinced that the arrest and detention of the judge inhibited his freedom to travel in Eritrea to perform his consular function for Ethiopian nationals. The Commission is not convinced that Eritrean officials questioning the judge for less than 1 hour constituted interrogation in the context of compulsion of evidence. Similarly, the Commission dismissed the related claim that the respondent violated Article 29 of the Vienna Convention on Consular Relations by failing to protect the judge from students allegedly throwing rocks at his car when he was leaving Medibur in October 1999.
Aziz v. Aziz. The Sultan of Brunei intervened in the proceedings seeking an order to prevent publication of his name or any material that might identify him in connection with the proceeding. The claimant was the Sultan's former wife. She became involved in litigation with a defendant over 2 audio cassette tapes containing material of a confidential nature. An order was issued early in the proceeding to anonymize them. An interlocutory order was issued banning the defendant from releasing the confidential information on the cassette. The claimant made an committal application against the defendant. She alleged that the defendant has disclosed the tape to one of the Sultan's representatives. The Sultan, invoking his status as a foreign head of state, sought direction preventing the publication of his name or the publication of any matter which could lead to him being identified in connection with the proceeding. He relied on the application to a head of state by Section 20 of the State Immunity Act 1978 of Article 29 of the Vienna Convention on Diplomatic Relations 1961, which is given the force of law by the Diplomatic Privilege Act 1964 and which, it is said, require the United Kingdom to treat him with due respect and take all appropriate steps to prevent any attack on his dignity. The judge refused the relief sought. He drew a distinction between a head of state in his public and his private capacity. So the Sultan appealed, but the appeal failed. The application of Section 20 State Immunity Act requiring the United Kingdom, including a court, to treat a head of state with due respect and all appropriate steps to prevent any attack on his dignity apply equally to the foreign head of state in his personal or to his public capacity. But an attack on the dignity of a foreign head of state must entail some elements deliberately offensive or insulting words or behavior, and mere protest, no matter how noisy, or criticism, no matter how robust, would not appear to be sufficient. And outside physical attack or interference, the material in relation to the prevention of offensive conduct support the view that, to the extent there is any uniform practice amount to no more than courtesy or community, and whatever the content of the duty in international law of the United Kingdom to take appropriate steps to prevent an attack on the dignity of a foreign head of state. There is not the slightest trace of any conduct in the present case which could, even on the most extensive interpretation of the notion of attack on dignity, be such an attack, nor was there any interference with the dignity of the Sultan.